Good afternoon and good evening, everybody, wherever you are located in the world. I want to wish you a very warm welcome. My name is Mia, and on behalf of Legit Software and our esteemed partners at Turki Alrashdi Law Firm, it's a real pleasure to have all of you today. And today we're going to be cutting through the complexity of Saudi Arabia's PDPL. So this is a joint session. It's all about moving beyond theory and taking real measurable steps towards operationalizing your compliance. And so we will be talking about privacy risks in the kingdom. Because data privacy isn't just about ticking boxes, it's about meeting fundamental requirements under the PDPL. And what we hope that you will learn in this session is how to identify and manage privacy risks in a very structured way. We'll be talking about assessments, how you can save time and reduce human error. We'll be talking about third-party risks, and how we can build a proactive risk management framework that scales easily. So if you're responsible for handling personal data, this session is designed to give you clarity, confidence, and control when it comes to PDPL. So we also will be taking questions throughout this webinar. Please feel free to write them in a chat. And then at the end, there's going to be a dedicated time for Q&A with our experts. So please use the platform. And now, to guide us on this journey, I'm thrilled to be joined by two exceptional experts. First is Mr. Turki Alrashdi. He's the managing partner of Turki Alrashdi Law Firm, and he's one of the most trusted voices in legal privacy landscape in Saudi Arabia. He has advised top public and private sector companies, helping them to navigate PDPL with precision and foresight. And second, we are joined by Marijan Bracic. He's one of the co-founders of Legit Software and the creator of our very own and flagship data privacy manager DPM platform. He is a pioneer in privacy automation with over 15 years of experience in data management, using technology to scale compliance in a very practical and effective way. So hello and welcome to both of you.
Thank you, Mia. Great to be here.
Great.
Thank you very much for the introduction, Mia.
Yes, of course. So lots of questions today, so let us dive right in. Okay, so Turki, let me start with you. And so Turki is going to remind me, but I will be ahead of him. Whatever he says, it's not illegal advice. But feel free to go to Turki for the said legal advice, because he is definitely the expert. But it's great to have a view, points from such an esteemed lawyer, as well as the technological perspective from Marijan. So let us dive in the central administrative requirement under the PDPL. When we talk about records of processing activities, or ROPA. So from a very strict legal perspective under the PDPL, what is the single biggest risk organizations face when they manage ROPA manually with, like very fragmented spreadsheet? And then I have a follow-up question. So let's start for this.
Great. Actually, thank you for these questions, because as a lawyer who practicing privacy and advising the client in the privacy matters, and also advising people in technology matters, I always advise my client that most of the issues coming from manual spreadsheet are often uncompleted. The data, it's outdated and inaccurate, which means the ROPA fails to reflect the current vendor and data flows. If the ROPA wrong, as you know, your contract will be wrong, policies will be wrong, and compliance will also be wrong. So This is I can say one of the biggest challenge that in the separate sheet a lot of function will be not available, so you cannot know who give approval for what, who is responsible for what, and so on, and even from documentation perspective as well.
Okay, very interesting. Thank you for that. And if auditor will come to a company that has these very fragmented spreadsheets, what would this auditor be looking for that a spreadsheet would fail to provide?
Let's say accurate and up-to-date data to
Mm-hmm.
assess the real risk. So as you know, we always say ROBA is living documents. And one
Mm-hmm.
of the separate sheet issues that will be it cannot be living, right? It's you cannot understand exactly what was the last input in this file, who did what, who gave approval for what is the history of this file. So you will lose the accuracy of the data inside separate sheet, and then the auditors maybe cannot assess the risk in best practice, let's say.
Okay, thank you. That's very illuminating. So, Marian, what would be one way how we could stop relying on these very fragmented spreadsheets? What would be the way to solve this technologically?
Well, obviously, I think first we need to do is start thinking about ROPA as a document, because when we say document, we think about the spreadsheet. But it is actually a whole range of business processes that need to be happening in the company, including how you assess whether a new product or a service needs to be documented as a record of processing activities within the ROPA. If it's documented, whether you need to do a privacy risk assessment. If you need to do a privacy risk assessment, whether there's going to be some risks coming out.
Mm-hmm.
If there's going to be some risks coming out, how are you going to tackle, manage, handle, mitigate, manage residual risks, and so on. So actually, the ROPA is the heart of privacy compliance. It is living and beating heart. And if you think about it as a document, you are being overconfident in your current state of compliance within the company. Always, it's like the Titanic story when they didn't have enough lifeboats because they were sure that the boat is unsinkable. So what you need to start thinking about is how to build and automate processes around keeping and managing records of processing activities. And this is what, of course, we do through privacy management software like DPM.
Mm-hmm.
But from the point of thinking about it, I think the most important thing is, even if we take the risk angle, is start thinking about it as a set of business processes, something that needs to be embedded in your business, not as a document.
Right. Oh, thank you. I think that's a really important thing to emphasize. So moving on from Europa for a moment. So I'm going to start again with you, Turkey. PDPL also makes it very clear that organizations are liable to third parties. So in some sectors, I mean, in a lot of them, but for example, in banking, outsourcing is very common. And the PDPL makes it very clear that the organizations are liable for their vendors. So, what is the minimum standard of evidence? Such institution like a bank would need to demonstrate to the regulator that its third parties are compliant in order to avoid a liability.
Thank you for these questions, Mia. I think there are three things need to be under telescope during your time for outsource or using third party for processing your data. So due diligence is will be the first, understanding who your vendor is and where they are based and where the data flows. For example, because the data is going to vendor A and data remains in KSA, it does not mean that is this is the case in the all time. For example, vendor A, maybe he will subcontract this business to someone else, and that let's name it vendor B will also subcontract the work for vendor C and so on. So you maybe need to understand exactly and know your vendor 100% through very organized due diligence procedure. And after that, of course, you need to start use the right agreement other than you use a DBA or which is a data processing addendum or data sharing agreement. This is need to be defined very carefully. Also, you need to sign a standard contractual clause if data is leave the KSA and conduct the, let's say, a transfer risk assessment with the third party, and also make sure that vendor reflect all the liability between you and him to his subcontractor as well, to ensure uh, everyone have the same obligation and understanding exactly the standard that the controller looking for.
Okay, thank you. So it seems that the more vendors you have, the more you outsource, the complexity really grows, because then you really need to focus on what is this vendor doing, if they're outsourcing this to somebody else. So it's a very, very complex thing to do. So and the end client in this my fictional example, a bank is liable, but really the compliance teams, it's really hard to manage these complexity manually. So Marijan, what is the biggest technical gap when you're trying to move from this so-called paper-based compliance to really operationalizing privacy across large departments? And let's maybe just talk about the third parties here.
Okay. So when we talk about third parties and risk related to third parties, this is like an interrelated risk. So the bank or the company that is the controller will typically have multiple processors that are involved in processing the data, whether they are vendors or maybe sub-processors, which are vendors working for vendors. So it can be a very deep distribution supply chain. What we need to do from technical perspective is have control. Like Turki mentioned, we need to have the legal framework around this partnership and how the processors are not just processing data, but protecting data. So typically companies from technical perspective will have some kind of vendor management platforms which are built for procurement and for financial piece of the puzzle. What we need to be aware is that you as the controller need to keep track of the risk continuously. So you need to be in contact with the vendor, making sure that they are properly protecting data. And this is your responsibility. You are accountable as a controller for this. And technically, what we need to do is at this point, we are typically doing continuous assessments with the vendors. So these assessments cover both privacy and cybersecurity risks. And we are continuously calculating risk score for the vendors so that we know which vendors are safe, which are risky, and which are of extreme risk. Then we need to have a managerial decision if whether we're going to continue working with the vendor, what is our risk appetite as a company. But first of all, we need to keep track of the risk score and continuously do these assessments. Now, besides just doing the assessments, we need to keep track of the contractual relationships. So if someone is helping us do our marketing activities, or if we have a vendor for HR activities, how is this covered in contracts? What is their obligation? What is our obligation? Are we allowed to do audits? How deep can we go? Can we test their systems? Can we test their data protection measures, technical and organizational? And the most important thing is when we talk about technology to keep us going, to make sure that we are continuously doing this, that the right people on our side, the right people on the processor side are notified, that there are workflows around it. And basically, the technology comes in as a centralized way of keeping track of the risks and also as a workflow for automating this, right?
Okay.
Because if you are doing this manually, either someone will forget, and this is typically what happens. Companies forget.
Of course, of course. You know, this is a very new area for a lot of people. PDPL hasn't been around for a very long time. So I think it's really interesting for all of us to start having these conversations to really learn more about the complexity of the challenges that we're facing. And from hearing the two of you speak, I understand that data compliance, it's really both not only a legal challenge, but a technical challenge as well.
No, Mia, it's very easy. Yeah, the challenge is that it's becoming more and more complex. You know, as there is a practice emerging, as there are judicial decisions, as there is multiple different jurisdiction and geographies, and you have global companies working in the KSA, so you need to keep track of the vendors within the country, outside of the country, all the different regulations that apply. So it is becoming very complex, but the key thing is that you are continuously assessing the risks and you are keeping track and monitoring the risks. And then we can deal with the risks. So we have seen companies who have zero identified risks, and we have seen companies who have tens of thousands of individual risks that they are managing. So the truth is somewhere in between.
Somewhere in between, definitely. And we clearly have a module that can help with all of this.
Of course, I mean, if you think about privacy management and privacy automation, you cannot avoid thinking about it as a risk management exercise. So the risk appetite of the company, how much are you gonna invest in privacy depends on how willing you are to accept certain risks, because it is very difficult to be 100% compliant all the time, because there are human errors, organizational errors, business process errors. There can be bad actors. So a lot of things can happen. So you cannot be 100% sure all the time that you are perfectly protecting your customer and employee data. However, if you are continuously keeping track and monitoring risks, and if you are using technology to identify these risks, to recommend risk mitigation measures, then you are on top of the game. Because manually it is not possible, because you need to have all the departments all the time be thinking about privacy, not about their core business. And this is why we have the risk module within the privacy management platform. So you want to outsource the thinking and management of risks from all the departments centrally to the privacy management platform. Of course, we use AI for this as well, for recommending risks based on the input, and input can be ROPA, input can be third-party risk assessments, input can be data protection input assessments, legitimate interest assessments, PIAs, pre-assessments. So all the different parts of privacy are combined together to make sure that we have a central overview, like a holistic overview of all the risks that can appear.
Thank you. That's super helpful. You know, and when we're talking about the risks and defines. So, Turki, when we look at actually beyond the financial fines, because of course there are fines that are quite hefty, what are the often overlooked reputational and operational costs large enterprises in the kingdom face when they cannot immediately prove compliance to the regulator?
Great. Actually, as you know, there are things sometimes will be more affected from losing money, especially when we talk about business side. Brand damage is always something impact the business, let's say big time. And also when we talk about losing the trust from the client, and that bring to my mind and a story. We can take it as an example. If you heard before about a Facebook valuation for the privacy with Cambridge Analytica. It's about a
Oh,
third
yeah.
party using the data from Facebook through one of their app, and without the consent from the users, they start entering to their friends and their contact, and they start profiling them and giving like preference for election in the US government. So imagine actually there was a big fine, like it's 5 million, 5 billion as I remember, but there was damage in the repetition, there was damage in the trust, there was dropped in the stock of Facebook, and there are
Mhm.
also, their CEO was enforced to be speaking in front of the Congress. So imagine the impact. So solving this kind of issues is take a long time, and paying the fines maybe will be the easiest action to do, but not dealing with other impact, which is will cost you a lot of healing procedures and start doing or adopt more privacy practices in your organization. So this is about the damage and what the organization maybe get other than fines and finance damages. And also, I want before to forget to highlight something very important Marian mentioned, which is that he really simplified the privacy in one word. You know, all our business is about mitigate and maintain the risk. So
Yeah.
it's always about manage the risk and understanding that there will be consequences for violating the privacy laws other than here in Saudi Arabia or outside the kingdom. And now the world and individual and organization, they start be more care about their privacy, their data, and understanding that there are a lot of impact can be arise when you like ignore the individual privacy right.
A lot of things to unpack here. This is
Definitely.
just the typical day in the world of data privacy. Lots to unpack, lots of details to look into. Really, not a dull moment every single day. But I want to cover a few other things while we're talking about the PDPL. So one of the things is the DPIA, the Data Protection Impact Assessment. So this is really central to the PDPL. Why is this a mandatory legal requirement? And what is the core business decisions DPI forces a company to make? So let's start with why is this a mandatory legal requirement, and how can you actually differentiate which activities need this assessment and which don't?
Great, great questions. Actually, the data protection impact assessment is the law's way to assess the risk and give you a clear understanding about the processing activity you are moving to do, and it's done when you are processing high risk data in order to
Mhm.
give you an idea, or let me say, as we mentioned earlier, it's all about managing the risk. There are a risk you can accept. There are risk is more than the level that you can accept. So this is the end result from the assessment, that you will ask questions, and there are something I usually see in the market, that the practice team only working in the assessment, which is something like I can say will end very bad, because you need the assessment is means you need input from others department, like you are processing data for marketing purposes. Okay, are we using the right lawful basis? Are we using the right purposes for processing? Are we going to transfer this data? Where we are going to transfer this data? To which country? To which third party? To which processor? Who will going to see this data? At the end, the decision will be made that, okay, are we going to process this data or not? If I
Mhm.
move forward and process this data, and tomorrow the regulators came to me and tell me, look, you process this data, so what the procedure you take in order to protect this data, or apply a principle like data minimization and so on. So you will show him that you have already documented data protection impact assessment, which is, by the way, named in the PDPL as a privacy impact assessment, so that maybe sometime will create confusion. And this is what we can, if we can give the right definition for this, it will be, as we mentioned earlier, a tool that will allow you to make decision based on understanding of the risk and documenting this risk and the measures you will take to avoid any data breaches or evaluation for PDPL.
Okay, thank you. And Marijan, how can we automate these assessments?
Well,
Or rather, can we automate this?
for sure, we can automate the assessments, and typically how we do this is we have a set of questionnaires which are initially sent to the key stakeholders. And when I say key stakeholders, this will typically be people that are operationally working or strategically working on introducing new products, new services within the company. So new kind of data is being collected and processed in a new way. And what we initially do through technology, of course, is make sure that they fill in the questionnaires, explaining what kind of data is going to be processed, how they're going to process it, why they need to do this, what is the impact going to be. So what is the volume of the number of individuals and volume of data that's going to be processed. So the initial result of the pre-assessment, as we call it, is whether it is a risky processing, so we need to do a privacy impact assessment, or we are fine, maybe it doesn't even contain personal data, so we don't need to do it. We don't even need to create a record of processing activity. Now, when we send out the questionnaires, typically the answers will come, and the privacy team, privacy operations team, or DPO, will be notified. They will be the ones setting up the result, and basically either starting a DPIA or doing a DPIA, depends on what is the privacy governance model within the company. But the key thing is that the automation part comes as a set of as a knowledge base with the questionnaires, as the process of sending, receiving, sending questions, receiving answers, notifying the right people, making sure that there are right steps in the process. So if the result is that the DPI needs to be done, then the processing activity lights up and says, warning, we need a DPIA, right? We have 10 activities where a DPIA is needed, and then we can start a DPIA, connect the processing activity with the DPIA, and so on. On top of this, what is the result of a privacy impact assessment? It's not necessarily just a go, no go. It is also potentially a set of identified risks. So the risks can be that we need more security when it comes to protecting and storing sensitive information. Maybe we need encryption. This is like the company policy. So there is a risk, like data is not encrypted. So it is maybe medium or high risk within the company, because also what we do through technology is customize risk methodology, make sure that it fits the current procedure policies within the company. Because when we talk about throughout this webinar, we are talking specifically about privacy risks. These are risks to the rights and freedoms of individuals, and making sure that the company's risk is minimized when it comes to privacy compliance. We are not talking about operational or financial risks. However, the company might have a common company-wide risk matrix where they use quantitative methodology to calculate and manage risks. So this is where we come in.
Thank you so much. And when you start filling out all of these assessments, do we have some kind of AI helper that can flag certain things or suggest risks?
Yeah. Yeah, so what we do with an AI agent is that based on the inputs, and like I said, the inputs typically will be how are we processing data, what kind of data, why do we need to do this, which part of the organization is the owner. What we have in DPM is a risk library and a very comprehensive risk model, and on top of this, an AI agent. So what it does is actually making sure that based on the input and based on the knowledge that it has, there are no risks, or if there is a risk identified, then the privacy team gets a recommendation saying this is potentially a high risk processing because of not enough technical security measures, also data is not protected properly, or maybe too many people have access to the data, or maybe you shouldn't be processing biometric data. So there is a wide range of potential risks that might be applicable, and we use the AI agent to basically automate this part of recognizing, identifying, and recommending to the privacy team which risks should be taken into calculation.
Thank you. When I speak to lots of different companies and people who are in charge of data privacy, they all seem to have one. Well, there are a couple of things that they have in common. One such thing is actually figuring out, they're like, but I don't know where we store all of our information. Where do we hold, let's say, passport numbers or names, surnames, IBAN numbers? Because this is fragmented throughout the organization. It can be in different databases, scattered, also possibly geographically. And the first step in protecting data is actually knowing what you have and where you have it. How do we solve this?
Okay, I think this question is for you, Marijan, right?
Yeah, I was on mute. Sorry. So how do we solve this? Typically, when we do the implementation of the privacy program, we want to understand the data landscape where we have all the personal data. And the first thing that our clients do is they run data discovery scans and do the use again our AI to understand where they have personal data and what kind of personal data. So from risk perspective, you cannot know the risk or understand the risk or protect the data if you don't know what kind of data you have and where the data resides, right? So I would say that is probably the most important first step. And not to take too much time, once we know, in my answer, I think I know, Mia, you have much more to questions.
Sure.
But once we know where the data is, and this is kind of a technical angle. And why I say technical angle, because companies might have a lot of different databases, applications, documents. So we've seen hundreds of millions of documents, and I'm talking about Word documents, PDFs, images, scanned documents, email servers, and so on and so on. So really, once we know where data is, we want to be able to find specific individuals' data, because of course, we need to minimize the risk of non-compliance, because if someone asks you to provide them with all of your data, you need to know where you keep their data as well.
Yeah.
And then on top of this, we start building this, what we call privacy program management, which is the ROPA. And the ROPA is a little bit different than the data inventory and data discovery, which is, like I said, more of a technical angle. So we connect to the system and we find all the data. Now with the ROPA, we need to understand why. Why are we even collecting all this data? Why are we processing this data? And the business will know for sure. If you ask marketing, they will know, well, we need phone numbers, email information, physical addresses, age, gender. So why do you need age and gender? So because we want to segment the customers. And then the privacy team says, but we don't have segmentation within the ROPA. Yeah, we segment customers all the time. We have we segment by gender, by age, by different types of preferences. So you collect preferences as well. So this is where the conversation starts between the technical part and the business part. And with the ROPA, the risk management, the data subject request management, incident management, which are all the modules of the privacy program management. We can also talk about consent management, so making sure that we are honoring individuals' choices, that all the data that we process is in line with the opt-ins that come from the individuals. And also finally making sure that we actually delete or anonymize, remove data once we are not allowed to use it anymore. So this covers the whole landscape. But again, the first step is typically discovering data and using AI to do the classification and understand what we actually have.
So, why would then AI-powered data discovery find what the humans may miss?
Because it's a zero trust approach. So when you ask marketing, they will forget about the preferences they are collecting. So they may ask you what kind of music you like, and they don't regard this as being personal data. Or they may ask what is your age, like age group. They will probably forget to tell the privacy team about that. So once we connect and do the data discovery, we find all different types of personal data that's because personal data is anything that alone or in combination can identify an individual, right?
Absolutely. And while we're actually talking about AI, our audience wants to know that basically organizations shouldn't really rely totally on AI without having a right control of the said tool. Can you maybe comment on this?
Sure. We are, I would say, at the crossroads. So AI is becoming more and more useful, even in privacy. There's a lot of AI being used within our software as well. But in general, you must make sure that the way you use AI is appropriate and in line with the regulation. So there is still like this wave of AI regulation that is coming. And the most important thing is that if you are a serious business, a company, you must have a transparent insight into how the AI service that you plan to use has actually collected data and what are the potential risks when it comes to personal data and sensitive information. So if you are using ChatGPT, you don't want actually everyone from the company sending companies confidential information, uploading that to the OpenAI servers. Like that is maybe the most common example. So most of the enterprises I'm working with do not allow this large language models usage for their employees. So what is the initiative within the large enterprises, whether to deploy their own LLMs within the company, which are internally where there is no data leakage, or to build their own agents or to have vendors that do this. So it's a little bit early, but from general perspective, it is very important to understand what your employees are doing with AI, how they are using it, and what is the data that is being shared with the LLM servers and companies.
Thank you. That's really a very comprehensive answer. So to wrap up my questions, and then we'll start to take some audience questions. I have the final question for both of you. What is the first step that a client needs to take when they start their data privacy journey? Let's say we're completely new. We don't, we might have some processes, but we're not really very yet. We just want to start our journey. What is step number one?
Yeah. I go ahead or you first, Marian?
Either, but I would like to hear.
I was talking too much, Turki. You go ahead.
Drink some water. Okay. Let me say, actually, it's amazing questions because first step is the most important step. So I can say the first step first, let's understand what is the personal data. Let's start by giving everyone the awareness, adapt the machine or mission of comply with the privacy law, understand that individual privacy is matter. So then we move to the next step, which is very important as well, which is about you cannot protect what you don't know that it exists. So you need to understand what kind of personal data you are holding, you are processing, you are sharing. Who is your processors? Who is the third party you have? Who is, let's say, where is the data you are processing? Is it inside Saudi Arabia? Is it outside Saudi Arabia? So understanding all of this, then you will start operate this privacy, start draft your privacy policies, privacy notice, start working in your ROBA, start documenting your privacy impact assessment, define the right lawful basis for each data processing purposes, and so on. But everything starts when everyone adopt that privacy is matter and then understand what kind of personal data they are processing and where is it. So I go through a lot scenarios like people tell me as a Maria mentioned that they think this information is not personal data, is not covered by PDPL, like a preference, individual preference, uh, or cookies technologies, or even some visitors information. They inform me like we must collect visitor information. It's for our own security. It's even if you have a valid reason, you need to consider this information as a personal data and treat it in the way that, um, let me say, protected and comply with PDPL and the privacy law.
Thank you, Turki. And Marian?
So in the light of what we are talking about today, I would say I really hate umbrellas. Like me personally, I never wear an umbrella. If I go outside and I see that there are, dark clouds and Might rain, I still don't take an umbrella. Even if it's raining, I don't take an umbrella. But you can, this is like a risk approach, and my risk appetite towards rain is huge. But if you
hopefully not towards data privacy, though.
yeah, but if you are a business, you have to have an umbrella ready all the time. Yeah. And you cannot have such big risk appetite. And when we talk about data protection, bad actors, internal mistakes, it's raining all the time. It's raining all the time. So you need to have an umbrella. And this is what we are doing. We are creating an umbrella. All the technology and all our services and everything we are doing, it is a big umbrella. Sometimes, your shoes are going to get wet a little bit. But what we are trying to do is try to keep you dry all the time. And I would say the first thing, of course, that you as a business need to do is get an umbrella.
Yes, absolutely. Get an umbrella. Get an umbrella, everybody.
Amazing way to describe the situation, really. But I have questions here. Are you really not using an umbrella even in the rain time?
No.
We need to discuss about that.
So that concludes my questions. I'm going to open now sometimes for the audience to ask the questions. Please feel free to either ask them in the chat or using the Q&A button. We already have actually some questions, so let me make sure that I ask them. Okay, so when it comes to the platform like DPM, I think, Marijan, you're probably the best person to answer this. Do you need some kind of technical expertise to actually use this platform?
No, we try to make it as simple as possible. So what we do is, so how we approach this is we provide the technological platform and all the services needed to get it up and running, to have your data onboarded, to have your people onboarded, and then it starts working for you. So this is we try to make sure that everything is done in the most simple way possible.
Okay, thank you. Turki, this one is for you. If we use a platform, any platform, does this mean we are now legally covered? You're muted.
Yes, absolutely not, Mia, because software is the only enhanced technology. It will not do the job in your behalf. If you don't have the right procedure apply in your organization, the right policies, and you don't know what you are doing, so software will not cover this for you, and even you will not get the value of the software. You need first to work in your infrastructure, in your understanding, and start identify each and everything. Then software will be very valuable for you. But want to check you if you are not.
So it sounds to me like you need to get your framework correct first, exactly, and then you let the software do everything or most things so that you can focus on the business itself.
100%. If you are understanding that privacy is matter and then start this progress, then you will start using, rather than doing data discovery by your own, use technology is will cut some of the time. You will automate this, automate that. You will know for each task what kind of technology you need. But if you just have the technology, but you didn't use it, or you didn't build the infrastructure for it, then it will be pointless.
Right. Okay. Thank you. Turki, you are very popular, so this question is for you as well. Basically, if we're using a third-party vendors, which we are, and they're global and already GDPR compliant, do we still need to manage these third-party vendors? Do we need a module for that?
Of course, you need to assess this third party in the right way, because even if if they are comply with GDPR, for example, it doesn't mean like they are 100% comply with PDPL. As you know, there are localization obligation in the PDPL, like when you transfer the data and so on. There are obligation related to incident report timeline. There are also NDMO insight. So there are things that you need to be considered during third-party assessment. It doesn't mean that he is high comply with GDPR. That means he will be with PDPL by default. So you need to consider assess him based on the PDPL.
Thank you. And Marijan, last but not least, because we have time for one more question. So our audience wants to know basically their environment. They have lots of different databases, as well as cloud solutions. So can data discovery integrate with that and find all the personal information in these kind of environments?
Yes, of course. The platform was designed to be able to connect to anything. What we do when we connect, whether it's an on-premise server database application or it's in the cloud, we scan it, we read the data and metadata, and basically find all the personal information within the platform. So in short, the answer is yes, we can work with anything.
And does it work with Arabic language? That's
yes,
correct?
it does. Yeah, I'm very happy to say it does.
Fantastic. Is it already deployed in the kingdom?
Yes, we have several deployments.
Okay, fantastic. Well, this is really very, very exciting. So let me just see if there are any more questions from the audience. No, it seems like we have wrapped our questions up as well. I want to thank everybody for taking the time to join us for this webinar today. Thank you to our audience. Thank you to our experts. If any questions pop up at any point in time for you to know more about data privacy, please feel free to reach either to any one of us. We are here to help you on your data privacy journey. So follow us and contact us, and don't hesitate to come back. We're here for you.
Thank you, everybody. Have a nice evening.
Thank you. Thanks, everybody.
Enjoy the rest of the day. Bye.
Thanks. Bye.